Good morning, Mr. Hlatshwayo. Good. Are you ready to begin the interview?
Yes, Chief Justice.
Thank you. You're an alumnus of the University of KwaZulu-Natal. Is it Durban Westville? Because I
Yes,
see Westville in brackets.
it used to be Westville, Durban Westville.
All right.
It is now KwaZulu-Natal University.
And you obtained BUris and LLB degrees from that university.
Yes, Chief Justice.
You're an attorney. Well, you come from the ranks of the sidebar. You did your articles from 2000, then obtained them, built your way up until you started your own practice.
Yes, Chief Justice.
When was that? In 2007.
Yes, Chief Justice. Even though
Hlatshwayo and Associates.
yes, but prior to that, I also practiced in partnership with another attorney.
At Bell and Associates.
Yes, Chief Justice.
But there are a few other. Well, you were involved with a few other law firms, I see. But you opened yours in 2007 and ran it until 2010.
Yes, that's correct, Chief Justice.
And during that period, you started acting as a magistrate.
Yes, I started acting in 2008 as a district magistrate, and I was appointed in 2010 as a magistrate.
Until 2020.
Until 2020, and in 2020, I was appointed
in the regional court.
In the regional court, after acting also for about 2 years prior.
I'm sorry, commissioners. I'm finding that quite distracting. Sorry. I didn't sleep much last night, so my nerves are frayed as it is. Thank you. So you say you became a regional magistrate from 2020?
Yes,
to
Justice.
date.
I've been a regional magistrate from 2020 until to date.
All right. And you have enjoyed 5 acting stints in the High Court?
Indeed.
As a judge?
I did. I had the privilege of acting for about 5 stints before the application. I have subsequently had the privilege to serve 2 terms, which ended now in September.
So how long has been your acting stint in all? In terms of, well, according to court terms?
All in all, if I'm not mistaken, Chief Justice, it is about 30 weeks.
30 weeks.
If I add in the 9 weeks that I've served after the application.
Have you had occasion to write judgments in the High Court?
I did.
You listed only 3.
I think I submitted 4 judgments.
Oh, I missed the other one. So you listed only the ones you consider more important.
Yes, indeed. I only provided the ones that I considered.
All right. And I would imagine that during your long stint as a magistrate, you've sat in civil and criminal court and done your appeals and all that.
Yes, indeed. In the magistrate's court, I was honored when I came from the attorney's profession to be immediately assigned in the civil court in Durban. It is indeed a very busy civil court. So I was exposed to a lot of civil work there. I sat in that court until obviously I was rotated to other divisions. Essentially, I've been exposed to all divisions in the lower courts.
And in the High Court, have you been exposed to a wide range of work? Have you done appeals, sat in trial court, motion court?
Yes, I did indeed sit in both in civil courts and criminal courts, but mainly in the civil courts and mainly in Durban. It is only now that I spent some time in Pietermaritzburg. So I indeed sat a lot in Durban High Court.
And you consider yourself ready for senior appointment in the judiciary?
I think so. With my experience, Chief Justice, I think I am ready.
Well, most of the professional bodies who've commented on your candidature seem to agree with you, but there is one who went the other way. Is it? I think it's the Advocates for Transformation, who have registered a few concerns about your personality, I suppose, because they say you treated junior members of the bar down there aggressively, and that you were not open to persuasion on matters in respect of which you formed prima facie views, which implies that you go to court with a fixed mind how things are going to go. What would you say to those charges?
Chief Justice, it is difficult to formulate an answer because it is not matter specific. It is indeed difficult, but my entire experience in the judiciary has taught me to exercise a measure of judicial temperament and ensure that I give the opportunities to both parties to put their cases forward and also consider their views. I may at times, of course, engage in order to limit the issues and determine what is indeed in dispute. However, that has not in any way resulted. I've not had an instance where my engagement with counsel has gone to the extent that it had led to a situation where one can describe it as being aggressive. So
My apologies, CJ. Can we ask the mic to come closer?
Oh.
I'm battling as well.
We're struggling to hear you.
I
Yes.
think he moved his
Okay.
head to the side.
Thank you. I was saying that in my history in the judiciary, I've tried hard to ensure that I give a fair opportunities to parties to present their side of the case and be heard. And whilst I may engage with counsel, at no point did this generate to it being unpleasant or aggressive. In fact, when I look at the others or the other law bodies, it seems to counter what is being contained there. So it's difficult for me to formulate an answer because there are no specific issues that are being referred to.
Yeah, I understand that. Well, I must put this one to you as well. They say you are reluctant to deal with urgent applications, and that if a litigant dares bring an application for leave to appeal against your decision, you take that personally. But again, no specific details are
Yes.
provided.
Again, the same answer, Chief Justice. If I refuse an urgent application, it cannot be tantamount to refusal to deal with the application. If it is refused on the basis, or it is struck off on the basis of a want of urgency, or if I have considered it and determined that indeed a case has not been made out, it cannot be regarded as a refusal to deal with it. I don't think one can refuse to deal with a matter that is placed before him or her. Again, it is difficult to formulate an answer because there is no specific matter. I've also granted quite a lot of other leave to appeals. again, it is a difficult situation for me to formulate an answer without a specific matter being referred to.
Thank you, Mr. Schreckman. Do you have questions for the candidate, JP?
Yes, thank you, CJ. Good morning, Mr. Hlatshwayo.
Good morning, JP.
Maybe it will help the commissioners if you try to, I know it's hard there, to sit still so that they don't lose hearing you, because
Yes.
now and again your voice fades. Perhaps let me start where the CJ has ended. Just to record that I have not received any complaint, nor the DJP, that you refused to deal with an urgent application.
Yes.
So this, because when I saw that comment, I had to ask him. And those are the people that deal with allocation of work. So we did not get any complaint. But just on the issue of the being not open to persuasion when you have formed a prima facie view, are you open to persuasion? And what is your understanding of a prima facie view?
Well, when you consider the papers before you, you obviously entitled to have an understanding that a particular matter is going in a particular direction, but of course you cannot arrive at a conclusion before hearing both parties. You need to give both parties a fair opportunity to present their arguments and consider their arguments holistically before forming a view on the matter. So indeed, JP, I am open to persuasion. Otherwise, if one is to simply go to court with a view and not being open to being persuaded, it is against the spirit of giving a fair hearing to parties.
Yes. And then on the one for the leave to appeal, that they say you take it personally, what is your understanding of the test applicable for the leave to appeal, and in particular, what officer when they are dealing with a leave to appeal application?
Well, my understanding is that Section 17 of the Uniform Rules outline what needs to be considered. In particular, the one needs to be satisfied that another court would come to a different conclusion. It is indeed a high bar to be achieved by the appellant. However, one needs to always be open to give parties an opportunity to proceed to another court, so that their case could be tested. Perhaps you may have overlooked certain aspects of the case, but only if on proper grounds it is shown that indeed another court will come to a different conclusion.
So when they persuade you in the application, do you get offended, especially when they tell you that you have aid in accepting that or not accepting that?
No, JP, not at all. As I've indicated earlier, I've dealt with quite a lot of leave to appeal. I've granted few that are deserving. There won't be a stage where one would be offended by it. It is a right that is enshrined in the Constitution for parties to exercise their right to appeal.
Yes. So you were referring to Section 17 of the Superior Courts Act, not
Yes.
Uniform Rules.
My apology.
Yes, no
Yes.
problem. All right, let's just come back to your acting stints in the High Court. How have you found the work in the division?
It was indeed enjoyable. At the same time challenging. Even though my experience in the magistrates' court, especially in the civil court, had equipped me to be able to deal with a challenging motion court and busy civil court matters. But the complexities of the high court matters meant that you had to rise up to the occasion. Also, the senior colleagues were of great help. It is indeed a pleasure that I served in the division under those circumstances, JP. Thank you.
Yes. And how many judgments totally from the High Court have you ascribed?
From my calculations, there are about 31 judgments for the 30 weeks that I have spent in the High Court. I'm talking about written judgments only.
And what was the longest time that you took to hand down a judgment?
I would say 2 months. I've not gone above 3 months.
Yes. And just on your regional court, there's always a perception that judges don't have too much work, and at times it comes from the magistracy. So you've been a district court, regional court, and acted in the High Court. What is your view about that comment?
It is misconstrued. Indeed, I mean the level of work that one has to do in the High Court demands that you do not have a specific time that you work, even after hours or weekends. You have to dedicate yourself if you want your work to be done properly and for you to be up to the challenge. There is extensive work in the High Court, and the complexity of it requires you to always be at a particular level and do your researches. So I wouldn't agree, even though there is quite a lot of work as well in the regional court, but I wouldn't agree that there is less work in the High Court.
Yes. And in the regional court, do you have parties, and how many do you have?
The last time I checked, JP, there were about 7 parties. I must say that in the regional court, the circumstances or the conditions under which you operate dictates that you are always in court dealing with new trials, and most likely you're going to have challenges with those trials not being finalized for a variety of reasons. One witness is sick or multiple accused. So you try to deal with your cases on a continuous roll basis, but sometimes it is difficult, and the regional court directives say that you are allowed to at least at one time have 15, but last time I checked there were about 7, but those are easily disposable as well.
Yes. And one of the issues in the regional court, in KZN in particular, is the issue about the finalization rate of matters and the court hours. What is your average per month of your finalization rate, and what is the average of your court hours?
On average, I would say about 7 to 8 matters. Obviously, these are extremely serious matters because you're dealing with murders and robberies, and the evidence is long as well. It is similar to the High Court criminal trials at times. So, and when it comes to the hours, I would put an average to about 4 hours, or 3:45 to 4 hours.
Yes. On the appeals, you've sat in both the full court and the full bench.
Yes, Chief.
And I would imagine you have not scribed in a full court.
Not yet. I hadn't have it.
Yes,
The pleasure. Yes,
because that is the convention in our division. But you've scribed in the full bench.
Yes.
What have been the comments from the presiding judge of your judgments? What is the feedback that you have received?
Well, I've received good comments. At no point, when I worked with senior colleagues, my judgment had to be redrafted. In most instances, it is a question of sorting out one or two errors, but other than that, the substance of the judgment was always agreed upon by senior judges, and they commended my writing style, and so that is it. Thank you, JP.
Yes. And just on some law issues, what, in your view, are the jurisdictional requirements for granting a winding up order?
Well, the winding up order can only be granted if a party against whom the order is being sought has committed acts of insolvency, and therefore there are other whole host of requirements that need to be met for a court to grant that order, including service of the of the application. And in our division, we require that an interim order be obtained first before a final order is granted.
And lastly, under what circumstances is an application for reconsideration brought before the judge?
Generally, it is done where a matter had been where the application has been brought on ex parte basis, and therefore the other side has not had an opportunity to be heard. They have an opportunity within a certain period to bring an application for reconsideration.
Yes, thank you. Thank you, Chief Justice.
Premier?
No, also covered here.
Thank you, Premier. Commissioner Kotsa?
Thank you, CJ, and good morning, sir.
Morning, Commissioner.
I just want to perhaps clarify the extent to which you have dealt with criminal matters, criminal trials in the High Court. I see from your CV that you are a regional court magistrate.
Yes.
It seems mainly civil, but I then saw in your CV somewhere criminal. I just want to know perhaps the extent to which you've dealt with criminal matters in the High Court, also as a regional magistrate.
Commissioner, I've done 2 stints in the High Court, criminal courts. Both of those stints, I was lucky, or maybe with dedication, I finalized both those, both whatever cases that were allocated to me within the specific period of time. So I have in-depth exposure in criminal matters, also supplemented by the regional court, where every day one is required to deal with those criminal matters.
So just to get back to the AFT KZN letter, they say they do not support your application and that they're of the view that you could benefit from further training and acting positions. I just wanted to ask whether you think that is a fair assessment. And I also wanted to know their note that says, unfortunately, you took an application for leave to appeal against a judgment somewhat personally. Do you know exactly which matter that is that they're referring to, and what could have possibly given them the sense that you took it personally?
As I indicated earlier to the Chief Justice and the JP, it's a bit difficult because there is no particular matter that has been referred to, and I would perhaps have taken the liberty of listening to the record. So I'm in the dark as to how they arrived at that conclusion. But as I've indicated earlier, and the GCB also has indicated this, that I have engaged counsel on a number of issues where, in an attempt, obviously, to get clarity on the issues. But that engagement, at no stage has it degenerated to such an extent that one would say that I was indeed taking a particular issue, or I was taking it personally. So it is difficult for me to proffer an answer. Thank you.
Thank you, CJ.
Professor Marumahai? Okay.
Thank you, CJ.
Oh, there's a follow-up, sorry. Commissioner Kane?
Sorry to interrupt you, Commissioner. Just on the question of appeals, sir, is the test whether the applicant for leave would succeed in the appeal? In other words, must you be persuaded that they would succeed, or must you be persuaded that they'd have a reasonable prospect of success?
The reasonable prospects of success is ingrained in the test on as to whether they will succeed. Obviously, one will have to find that what they have presented to you, they have reasonable prospects of success. But the recent amendment in terms of Section 17 takes the bar higher because it requires that one must be persuaded that another court would come to a different conclusion.
Thank you.
Prof?
Thank you, CJ. Good morning. I had a question that I wanted to ask you, but there's something that the JP asked you that I could not really grasp whether you are familiar with it or not, and I want to pick on it. I'm not sure. Have you been able to deal with insolvency matters in that division?
Yes, I have. I've dealt with provisional sequestration, and I've dealt with
Perhaps-
final orders. Yes.
Perhaps then my question would be fair. The question was, what are the jurisdictional factors for liquidation? And your answer appeared to me as if you are giving the jurisdictional factors for sequestration. What I want to understand is, under what basis would a person want to liquidate a company, and which particular act is applicable under those circumstances?
Well, okay, maybe I did not understand initially. One of those, obviously, is that that particular company is unable to pay its debt, and that a particular demand has been made, or a return of a nulla bona has occurred. So, in my recollection, those are primarily the jurisdictional factors one has to consider.
And the applicable act?
That will be the Companies Act.
Oh, okay. Thank you very much, CJ.
JP Tlalezi?
Thank you, CJ. Mr. Hlatshwayo, in the annexure to the questionnaire, section 2 thereof, I think it's on page 18, paragraph 6. You indicate that your stint in the regional court that commenced in 2017, you gained valuable experience, and you indicate mostly in criminal cases. In the regional court, what I want to understand, do you have any load of civil cases that you deal with?
Yes, Commissioner, there are. I also sit in the civil court in the regional court.
Do you have a lot of cases to deal with? Because the increase in jurisdiction was to try and obviate the number of cases that are clogging the rolls in the high courts.
Yes.
Do the practitioners make use of that advantage in your area, or they still go to the High Court?
What I've found is that they are not so many as compared to the High Court. Previously, before the civil jurisdiction was extended to all the regional court, it was assigned specifically to certain seats, certain regional seats. Under those circumstances, the rolls were quite high, and therefore a decision was made to just extend it to all the regional court seats. But I have found that there are not so many. You have quite a lot of divorces, you have quite a lot of applications, Minister of Police matters. But as compared to the High Court, I do not know. I mean, they are not as many as compared to the High Court. I do not know the particular reason why that is the case, but perhaps maybe because some of the courts may not really have the expertise. I do not know.
Yes. So mostly cases which would have been held in the regional court are taken to the High Court.
I've seen a lot in the High Court that could easily have been determined in the regional court.
So would you say we need to build a lot of capacity in the regional court so that which are said to be closer to the public, that all these cases can be dealt with at that level rather than talking the high courts?
I agree with that, Commissioner, because as it stands now in my court, I sit 4 days 3 days in criminal court and 2 days in the civil court. So I have to alternate in both. So if there is capacity, it will definitely elevate a lot of work that is finding itself in the High Court.
Yes, I see. Thank you, Chief Justice. Thank you, Mr. Hlatshwayo.
Thank you, CJ. Good morning, Mr. Hlatshwayo.
Morning, Commissioner.
Just one from myself. Recently, the court has declared that paternity and maternity leave will be equal. So I always ask myself, what is the source of this power that the court has? If it is a discretion that the court has, what is the source of the discretion? Thank you.
It is difficult to answer. I've only read through the news. I haven't really read the question. The decision that was reached in the Constitutional Court. But I will imagine that the equality principle or principle in the Constitution will apply, but also the basic conditions of employment would also find applications. So that is it that I can imagine. I haven't really read the judgment itself, Commissioner.
But the decision that the court always take to either set aside the decision of the legislature or the executive, sometimes I take it as an interference on the other arm of the state. What is your take on that?
There is a fine balance that has to be achieved in determining whether the decision of the legislature should be set aside or yes. And obviously, the Constitutional Court has pronounced on the test that needs to be followed, in particular where the decision or the legislation that had been enacted does not serve the particular purpose that it was enacted for. The Constitutional Court has pronounced on how one can then arrive at a decision of setting aside that legislation decision.
Thank you, Mr. Kaza. Thank you, CJ.
Dr. Justice, could I just follow up on this? I'm a little bit both confused and concerned. Thank you. Mr. Hlatshwayo, it's just a question around the answer you've just been discussing now. Where does the power of a court to set aside legislation come from?
It comes from the Constitution, Commissioner.
Yes, and on what grounds can a court set aside legislation?
Well, where the legislation doesn't achieve the purpose that it was set out to be. That is my understanding, Commissioner. Where it is unreasonable and does not achieve the object and the purpose that it is set out to be, and it is not consistent with the Constitution.
All right, so if legislation infringes a right in the Bill of Rights, is that one of the grounds?
Yes, if it is inconsistent with the Constitution, it is definitely one of the grounds.
Yes, and are you familiar with the role of Section 36 of the Constitution?
Yes, Commissioner, it relates to the limitation of those rights.
What is the role of that section in an assessment of whether legislation violates a right in the Bill of Rights?
If it is shown that the legislation that the infringement of those rights is justifiable in an open democracy, one would be justified in limiting those rights.
All right, maybe I should just suggest that you brush up on this part of the law.
Yes.
Thank you.
I would appreciate it.
Thank you.
Thank you very much, CJ. Is it still morning?
Morning.
Yes, good morning, Mr. Hlatshwayo. How are you?
I'm good under the circumstances, Minister.
That's under the circumstances. Okay. Mr. Hlatshwayo, I see, I'm following with what JP raised about your work as a magistrate and having acted at the High Court as well. I take that because magistrates or regional courts are said to be closer to where the communities are and giving access to justice to communities. Now, my question relates to you coming from KwaZulu-Natal as one of the provinces that is vast, and also because we have this legacy of apartheid in terms of our infrastructure, but also in services. In your view, how do you see the way we are structured being able to assist in access to justice, and whether there are mechanisms that we should be able to put in place to assist to ensure that communities don't travel long distances to access a court, especially noting that you've dealt with quite the most vulnerable in our communities, women and those that are senior citizens sometimes. Do you think that the way we are, where our courts are, but also from the point of our country's structure, are we able to say that we are giving that access to justice to the most vulnerable? Your views on that?
Yes, Minister, access to justice is crucial for the rule of law. In fact, my view is that sometimes it is important to take justice to the people. This may also involve setting up courts where people are, and I do not see any reason why presiding officers would quarrel against that, because it allows access to justice, and members of the community from the from the most vulnerable and the people who do not have funds to travel to various courts, they will have an opportunity to state their case closer to where they are. That is one of the measures that can be put into place.
Maybe as a follow-up, Mr. Hlatshwayo, having been even a regional magistrate, are you able to share innovative ways that at that level you've been able to assist in ensuring practically how to support those communities? I'm not so sure which region, I see you were a regional magistrate.
Yes.
Which region particularly?
I'm in Verulam, Minister.
Or in Verulam?
Yes.
Okay. So how do we deal with such? I notice it's almost semi-urban, better compared to your other areas in Zululand and your Newcastle areas. But how do we ensure, what are creative ways that we've been able to ensure? Because these are the people, majority of them uneducated in terms of the legal framework, but coming to your courts, what have you been able to deal with?
Well,
looking
as
at those?
I've mentioned, Minister, in most instances, when we sit in these courts, you ready to start at 9 o'clock, and you informed that the witnesses are traveling from far. They're traveling from Ndwedwe and other areas which are outlying in rural areas. Sometimes you inform that they do not have money to travel, which is precisely the reason why it is important to take justice to those communities. When it comes to Verulam and Ndwedwe, they are not far apart. It is a question of resources being available to take the court to the people, so that cases that are coming from that court can be dealt there, and people in the area can see that justice is being done, and they can also attend themselves. That is all that I can suggest, that I can think of at the moment.
Thank you very much.
Commissioner Mangen?
Thank you, Chief Justice. Good morning, Mr. Hlatshwayo.
Good morning, Commissioner.
Amongst the judgments that you gave us, there is a judgment dealing with evictions, where friends loaned money to each other.
Yes.
And towards the end of that judgment, you made reference to the provisions of National Credit Act.
Yes, Commissioner.
You recall that judgment?
I do recall it, Commissioner.
And as part of your reasoning, you arrived at a conclusion that there was a contravention of the National Credit Act in a situation wherein people who are friends and are loaning money to each other, what the creditor was required to register with the National Credit, was required to register as a credit provider. Is that what you found?
No, Commissioner. I did not find that there was a contravention of the National Credit Act.
Yeah.
Quite to the contrary.
You.
I found that it is not applicable because my understanding of the applicability of the National Credit Act, it must be an arm's length agreement between the parties. It was that reason that I found that the National Credit Act was not applicable.
Was not applicable.
Thank you.
Okay. No, no, I may have read it wrong because that's how I understand it. That the arm's length transaction is one of the requirements.
Yes, yes.
In
I had
the
found
absence
it.
of that, then there was no need for the credit provider to register.
I found that, that it was not applicable because of that in particular.
Thank you so much. Thanks, CJ.
Thank you, Commissioner. There does not appear to be any more questions for you, Mr. Hlatshwayo. Unless there's anything you wish to raise with us, you are free to go. Thank you for making yourself available.
Thank you. I appreciate the opportunity. Thank you.